a seat, please. Welcome to the District Court of Appeal for this afternoon's docket, and welcome to our internet audience on live streaming internet. I'm sure all of you all as practitioners here are aware of that, and I'd like to remind you also that we archive everything so you can go back and see yourself, or you can get your friends, family to look at what a good job you did. Today's docket has been somewhat shortened by two continuances. The first case is Broadspire Tampa and Geico versus Irizarry. Counsel.
Michael Warrants for the employer carrier, Geico and Broadspire the appellants. May it please the court. I would like to reserve 2 minutes for rebuttal, please.
Counsel, you, keep track of the time. When the yellow light comes on the clock, that means you are into your rebuttal time if you represent the appellant.
Okay, I understand. Thank you. This appeal concerns the JCC's finding that the claimant's condition was compensable, and he ordered the employer carrier to provide benefits. We submit that there are 3 reasons why this order on appeal should be reversed. First, the claimant did not provide timely notice of her alleged accident. In addition, the judge abused his discretion when he allowed the claimant's IME physician to testify by telephone at the final hearing over the employer carrier's objection.
I thought you claimed that was an error of law in your brief. Are you saying it's abuse of discretion now?
Yes, I did in the reply brief.
Okay.
Finally, the judge found this case to be one of repetitive trauma, but there is no evidence that the greater hazard element of the VESTA test was ever met, and we claim that the claimant did not establish major contributing cause. Now, the notice issue is fairly fact-intensive. The claimant had been working at Geico for 3 years when, on September 8 of 2003, she was working as an adjuster. On that date, she remembers experiencing a sharp pain in her right hand while working. She left work that day, and she did not report this incident at all to anybody at Geico. Now, the unique nature of the case is that at the time, she was 8.5 months pregnant. So that afternoon, she went to a previously scheduled appointment with her OBGYN, and they decided to induce the following day. Now, when they induced her, they placed an IV in her right arm. 7 weeks later, on October 31 of 2003, she went on her own to Watson Clinic, and she complained of having pain in her right arm ever since that IV was placed there. Now, the doctor at Watson Clinic was never deposed, but his report was placed into evidence. And what he indicates in his report was that he did not believe that her condition was related to any kind of thrombosed vein, but he thought she had de Quervain's tenosynovitis. Now, his report is in evidence and shows that the claimant did not tell him where she worked, what she did not report any accident occurring back on September 8 of 2003. Now, the claimant did not report anything until November 3 of 2003. And at that time, she claimed that she had this wrist pain, and it was due to repetitive trauma. Now, a date of September 8 of 2003 was utilized, and on the first petition that was filed, they claimed the accident date was on or about September 8, 2003. Now, 440.185 requires claimants to report accidents within 30 days. Now, we know that from September 8 of 2003, she didn't report that accident within 30 days. There are 2 exceptions. If the claimant obtains a medical opinion that her condition is related to her work activities, then if she reports her accident within 30 days of receiving that medical opinion, then a lack of timely notice can be excused. The second exception is if there are exceptional circumstances involved in the case. Now, what the judge found in this case was that within 30 days of the claimant obtaining a medical opinion, she then reported her accident. However, there is no evidence anywhere in the record of a doctor informing the claimant that this condition was related to her work activities. In fact, both physicians that testified in the case, the claimant's IME and the employer carrier's IME physician, agreed that this condition of tenosynovitis does occur sometimes in young mothers. We maintain that because there is no evidence.
You're saying that Dr. Baltodano's opinion did not give her a basis to think the condition, the tenosynovitis, was work-related.
Exactly.
Yet she did report it within 30 days after that, didn't she?
She did.
So what is your argument on notice then? If she didn't even know by then, what she knew at that point is she at least had one doctor saying it's not related to the IV placement, right?
Right.
So what's the problem with her reporting it within 30 days of that?
Well, what we don't know is why did she think that? There's no evidence that a doctor told her that this condition was related to her work activities. There's no
Counsel,
evidence.
I don't know of any law that says that a claimant that makes a report of an injury that later turns out not to even be work-related. What's the problem with that?
Well, the statute talks about if the claimant reports her accident within 30 days of receiving a medical opinion that her condition is related to her work activities, the notice will be deemed timely. Now, in this case, there is no medical opinion.
When do you argue that she should have reported it?
When did I what?
When do you say she should have reported it?
Well, if she was at work, if what she says occurred, if she was at work on September 8 of 2003, she's working on the computer, and she says she experiences a sharp pain in her right wrist. If that occurred, then she should have reported that within 30 days. Now, if she comes back and she's
That's your argument, is that her window then would have closed
October 9th of 2003.
sometime after she went out on maternity leave, coincidentally the next day, I think, after.
Right.
Okay.
Now, but if it's a repetitive trauma case, Your Honor, if she's going back to the last date she worked and she's saying September of 2003, then she has to be within 30 days of that. I don't want to keep harping on this medical opinion, but I don't want the court to think that if she reported it on November 3 of 2003, she's not a doctor. She didn't tell herself that this was related to work. Now, she might have come to the conclusion that I don't know what this is, but it's got to be work. But she doesn't get a medical opinion. Without that medical opinion, then she does not fall into the exception of 440.185. Now, our second argument is that on the pretrial stipulation, the claimant reserved the right to call any witnesses either live or by telephone. Now, without any notice given whatsoever at the hearing, she called Dr. Belsol, her IME physician, to testify by telephone. We objected at the time of the hearing as well, told the judge we did not agree to any telephone testimony, but he overruled the objection and allowed the doctor to appear by telephone. Now, we maintain that this is error because Rule 60Q 1163 prohibits any telephone testimony without agreement by the parties. And we maintain that for the judge to allow the claimant Dr. Belsol to testify by telephone over objection was error.
You don't argue that the testimony was otherwise incompetent, such as hearsay or unqualified expert testimony, things such as that. You rely upon the
Q
rule. Okay.
That's correct. Finally, the judge found this to be a repetitive trauma case, and we maintain that if she, again, going back to if she had this pain on September 8 of 2003, she knew she had that pain, she knew it occurred at work, it's really a single incident case, it's not repetitive trauma. Now, if it is repetitive trauma, then she has to meet the Fester versus Teleflex case. And in that case, one of the elements is that the claimant must show that her employment exposed her to a greater hazard than that to which the general public is normally exposed. Now, the judge made this finding in his order, but there's nowhere in the record that anybody gave any testimony on this issue.
Counsel, if you've got someone, if you've got someone who's working doing input, and she testified that when she input these claims, she primarily used the keypad, which we all know from experiences at the right side of the computer keyboard. She used her right hand. Certainly we want rulings to be based on evidence, but are you seriously contending that the judge would need more evidence than that to conclude that this is something that the average person wouldn't do in the normal course of daily activities?
Well, Judge, I think with the high use by people of computers and no real evidence as to how much this was not a data entry person. This was a person who also spent time on the phone, so it was a combination of
She talked about some dates and how her job duties changed and how she did this more sometimes than at others. I understand your argument, but she did at least provide some input about dates and frequency of use, didn't she?
She did, Your Honor, but on the other hand, she also testified that she worked at that company for 3 years and had no prior problems whatsoever in her hands until September 8 of 2003.
You're really arguing causation there, though, aren't you, counsel?
Well, I am. But I do think they must at least, I think at a minimum, the claimant needs to show some evidence of meeting this greater hazard element. Now, finally, when Dr. Belsole was asked about major contributing cause, he couldn't say this was major contributing cause. In fact, he said that maybe the activity caused the need for this condition to be treated. At a minimum, he needs to say major contributing cause. He was asked about major contributing cause, did not answer that in the affirmative. Therefore, we maintain that due to there being no testimony on major contributing cause, the claimant did meet her burden. Judge, those are my arguments. So at this point, I will reserve the balance for rebuttal.
Thank you, Mr. Warren.
Thank you.
Counsel for the claimant.
May it please the Court, I'm Wendy LaQuesta. I'm here representing claimant. I'm going to go in the order of my brief and first talk about the first issue, which has to do with the telephone testimony. I think you're all familiar with the rule which says that testimony may be taken by telephone by the agreement of all the parties and the approval of the JCC. Our position is, claimant's position is that this issue isn't preserved because at no time did EC's counsel maintain below that the JCC was violating this particular rule when he allowed admission of this telephone testimony. If you consider the merits, so we think that the order can be affirmed on that basis. If you consider the merits, then it's our position that what the EC is really maintaining here is that the rule is a bright line rule that prohibits the judge from allowing telephone testimony when there's an objection. And we maintain that the rule is not a prohibition rule, it's a permissive rule. It allows the JCC to have telephone testimony when the parties agree. It does not say that the JCC cannot allow telephone testimony if there's an objection. In fact, the issue, when there's an objection, it remains open under the rule. And under the normal scheme of things, it would be for the judge to decide.
Why do you think that the rule was crafted then to qualify the agreement of the parties and not speak to the absence of agreement?
I think that the rule makes it easy in this day and age, and especially in workers' comp when there's so much done by telephone and deposition, to allow the parties to use telephones to keep the costs down, especially when you're talking about experts being doctors. I don't think that the rule was intended to prohibit or to change the normal scheme of things in all trial courts where there's an objection and the judge gets to rule on that objection. You know?
That's really the question I have. Is are you saying that there's a rule in workers' compensation or administrative law in general that sort of parallels the statutory rules we have in civil and criminal, which is the point raised on appeal must have raised with sufficient specificity at the trial court? I mean, I don't see any workers' comp cases that actually say that.
In terms of having to specifically mention this rule?
Specifically identify what the point is before the trial court if you're going to argue it on appeal. He did object. I mean, he says, he's very straightforward, says, look, we objected. The rule says you got to have agreement. And your argument is, well, that's not the argument that he raised, and in fact, he didn't make any argument at trial other than objection.
Well, I understand that you may not go for my preservation argument, but I do know that when you're talking about hearsay and objections for different things like hearsay evidence, if you don't say that it's not relevant or give the judge some kind of clue that they're actually violating a rule of evidence, then how can that judge be said to have abused his discretion, which is what our standard of review is in this case, abuse of discretion. If he's not made aware that this rule says, hey, you can't allow this unless we both agree, how can you say he's abused his discretion by just not lapsing back into a Binger-type analysis, which is what we say is the right standard.
Why would it be a discretionary issue in workers' compensation when the authority of the judge is derived only from statutes and the rules implemented pursuant to statute? And if the statute says, or the rule says, you can have telephone testimony only by agreement of the parties, why isn't he bound by that?
Well, there's, I think that my answer to that is that the judge has, just like a circuit court, just like a county court judge, who also have rules that allow for telephone testimony. Just like those, he has the authority to control the proceedings in his courtroom, and this is all part of it.
He has the inherent power to do that?
Otherwise, you're saying that a person can object and that a party, by objecting, can control the progress of a trial. And I don't think that that's the way that things normally work in any courtroom.
I want to know how the judge has authority to allow a form of testimony not provided for by the rules.
Well, the rules do provide for telephone testimony, and the rule just says that a judge can allow it if the parties agree. The rule does not say, as I said in the beginning, it does not say you can't allow it if the parties don't agree.
It doesn't say that you can allow it if the parties don't agree. Is that correct?
It doesn't say that, no. It's unclear what would happen when there is a dispute. And this isn't a case like the Easy Serve case where there's a situation where there's not an oath given. This is a situation where this trial, the EC's attorney was well aware of this man as a witness, well aware that he was the IME. He just didn't, and the deposition was canceled at the last minute because the doctor could not appear. And so he objected in an attempt to keep out the information. So, our position is that the rule is permissive, that it allows the judge to do this upon a proper analysis as to whether the EC's attorney was prejudiced in here. There's no issue of surprise. They're well aware of who he is and that he's their IME, so he's going to be their expert. They've seen their report. And there's not a question here that claimant's trial counsel intentionally tried to, not disclose him or didn't bring forth a deposition. So it's our position that there's a CSE to support affirmance under an abuse of discretion standard on this issue. On the notice issue, the crux of the EC's argument is because Dr. Baltodano did not expressly say the tendinitis was caused by the work activity, that the exception under 441.85(1)(b) can apply. And this is a fact question for the JCC to decide based on evidence and credibility determinations, and we submit that there's CSE to support the JCC's ruling in this case. Claimant experienced a sharp pain on the day before she gave birth. She said, "I'm focused on giving birth at this time." She got an IV inserted the next day, and then she had abdominal surgery when she had her C-section. I would venture to say that was probably a little more painful than what was going on with her arm. She said she didn't know what the cause was, and then when it persisted over the terms of her maternity leave, she went to Dr. Baltodano, and as soon as she had a conference with him, she immediately reported this injury to the employer as something caused by repetitive activity at work. Now, they say that, Baltodano didn't testify, and his report doesn't say caused by work activity, but Dr. Schur, their IME, said Dr. Baltodano told claimant that she had tendinitis secondary to repetitive activity. And we think that these are, this is CSE to support the JCC's finding that this was timely notice under 1B.
And the first manifestation was just before she went out for maternity leave, right? I mean, she hadn't had any pain prior to that last day she was at work.
I believe that's correct. She said she felt a sharp pain that day. It wasn't debilitating, but she felt the pain that day. And I think that that's one thing that I pointed out in my brief, that the EC's argument in this point in terms of prolonged exposure focuses on the prolonged pain. They've considered that this is just a single incident injury that occurred on September 8 and that her time ran from that. But under the repetitive trauma test, it is the prolonged exposure to the activity or the conduct, and there's plenty of CSE on that.
So having a sudden onset of pain would not be inconsistent with a repetitive trauma theory for recovery.
It's kind of like the straw that broke the camel's back in repetitive trauma cases. I mean, you can go along for a long time doing the same thing, and then all of a sudden it hurts you, or all of a sudden something happens. And although 1D is also an exception to the notice, and that's you can excuse timely notice for exceptional circumstances if they justify it, and I've also maintained that that's another basis to affirm the notice was timely in this situation because of her maternity leave, her abdominal surgery, she's arranging child care, she's a new mother, and as soon as she went back to work, she reported it. So I think that that's another, so that issue can be affirmed on that point too. Under Issue 3, which is the repetitive trauma, initially, there's two tests under FESTA. There's the prolonged exposure, and then there's the alternative test, series of occurrences, which the cumulative effect, which is injury. And we maintain that in the initial brief, they didn't make an argument as to the cumulative effect, series of occurrences, cumulative effect being injury, and so they've abandoned any issue as to that, and you can affirm the order based on the alternative test under FESTA. If you turn to the test under FESTA, prolonged exposure, cumulative effect being injury, and greater hazard, all of those we maintain are supported by CSE. Claimant testified, as Judge Kahn had pointed out, as to her activities, with keyboarding, that she had to pay bills and was always using that 10-number pad, that she had this job for 3 or 4 months and she did it all day. So this is sufficient for repetitive trauma, prolonged exposure to this condition of having to use this keyboard in this way. Cumulative effect, they say that Dr. Belso didn't say there was major contributing cause, and I'll direct you to pages 37 and 39 in Volume 1 of the record, where Dr. Belso specifically asked, have you formulated an opinion within a reasonable degree of medical certainty as to the major contributing cause? And he's twice asked major contributing cause questions, and each time he answers, it's the work activity that's causing the problem here, or the aggravation, or the need for treatment. So there is major contributing cause, and that's sufficient to get past this second prong of FESTA, cumulative effect. And as to the third, that's the special hazard. You have to remember here that this doesn't have to be some unique hazard, something strange or particular to this job. It's just a hazard, something that the general public isn't exposed to on a regular basis. And claimant testified as to that. She said she explained all her activities, how much she had to use this little 10-number keypad at work. She was given ergonomic equipment because of her job. And also she testified that when she was at home and used the computer, she didn't have to use the keyboard or the mouse to the same extent that she used it at work, and that when she was home, her pain wasn't as bad as when she returned to work, and after long days of keying, her pain was greater. So we maintain that there's also CSE to support that this is a special hazard. And that brings me to the end, and so unless you have any questions, I'll just conclude by saying that the claimant maintains that the JCC did not abuse his discretion by allowing telephone testimony under the circumstances of this case, and that there's CSE to support his finding that claimant gave timely notice of her injury, and that this is satisfied the repetitive trauma test to show a compensable injury, and we ask you to affirm the order. Thank you so much.
Thank you.
I would just like to say in rebuttal that what the claimant said in her brief as to why she reported this in November was a light bulb went off and led her to believe that her activities were caused by work. So I didn't hear opposing counsel point to any testimony from Dr. Baldadano saying that he provided her with an opinion that her work activities caused this. He didn't even know what her work activities was, and we cannot lose sight of the fact that After she worked the last day on September 8th, and the following day she gave birth to a baby, had an IV placed in her arm, and then goes to the doctor 7 weeks later and says, I've been having pain right there at that area ever since I had the injection site, and then cared for her young child, and both physicians testified that they do see this in young mothers, and then goes to the doctor. Nowhere in the records does he indicate that this was, he even knew what her work activities were. Now, I'll be the first to admit it's highly, yes, it is a coincidence that she goes in on November 3rd and says, well, I was told I had tenosynovitis and I want to claim this as work. But we don't know who told her that. There is no evidence of who told her that. And if she came out with that opinion on her own, if a friend told her that, if her husband told her that, it's irrelevant, because the statute speaks to there being this exception that you have to, after you receive a medical opinion. Now, if she had a medical opinion that was given to her, and then she went, pursuant to that medical opinion, she went to work and reported it, we would be talking about a different situation. But that is not what occurred here. Thank you.
Counsel, do you agree that there was no mention of this administrative rule relating to telephone testimony at the hearing below?
Not the Q rule specifically.
But that rule is the specific basis upon which you would have this court reverse on that point.
That's correct.
Well, what would be the theory for us to be able to do that when that rule was not even mentioned?
Well, I believe because the rule was not specifically stated, but the content of the rule was.
And how was that stated?
Because we clearly stated we did not agree to the doctor appearing by telephone. And the rule states specifically, parties must agree. We didn't just say object. We said object and do not agree. I was at the trial. Something told me it was there. And something told me you had to agree. And I just remember that you had to agree and I didn't agree.
Well, the judge might say the same thing, though, that he would have appreciated notice that this rule was there. I know the Q rules were only a year or so old at the time. I understand that, but
I understand the same thing, Your Honor. I would just say that it is a rule and it was violated, and that's our argument.
thank you, Mr. Warren.
Thank you.
Oh, excuse me, one other question. The trial judge didn't ask you for your authority for that, did he?
That's correct. Did not.